Hi guys, and welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we take up part 3 on the law of negotiable instruments, and I'll be giving you a brief overview of how a negotiable instrument works. I'll be discussing the incidents in the life of a negotiable instrument, and I'll be discussing rules of interpretation of a negotiable instrument. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now, let's first discuss the incidents in the life of a bill of exchange. Okay? Now, the first stage, if you would call it that, in the life of a bill of exchange would be the preparation stage. The drawer will complete all of the requirements of Section 1 to make a bill of exchange and cap it all off with his signature. Okay? The second stage will be issue or the issuance of the bill of exchange. Okay? It is defined under Section 191 as the first delivery of the instrument, complete in form, to a person who takes it as a holder. Okay, under that same section, a payee or endorsee of a bill or note who is in possession of it or a bearer thereof is entitled to receive the sum stated in that instrument. Okay, so in other words, it is the first transfer of a negotiable instrument to a payee. Okay, so delivery to be complete, of course, there must be actual transfer of possession, and more importantly, there must be an intention to transfer title and constitute or recognize the transferee as the holder of the instrument. Okay? Now, the next stage is negotiation, which is simply defined as the transfer from one person to another in such a manner as to constitute the transferee as the holder of the instrument. Okay? If the instrument is payable to order, then it is negotiated by endorsement, at the back, signature at the back, coupled with delivery. But in case of a bearer instrument or an instrument payable to bearer, then no need for endorsement. It can be negotiated by mere delivery only. In both cases of order instrument or bearer instrument, delivery must be with intent to make the transferee a holder. Okay? Excuse me. Now, when it comes to the next stage, it is known as presentment for acceptance. And this applies only to bills of exchange, okay? And this is the production of the bill of exchange to the drawee for his acceptance, okay? As a general rule, presentment for acceptance is not necessary to render any party on the instrument to be liable, okay? It's not necessary to make them liable, okay? Except in the following instances where presentment for acceptance is necessary. First, where the bill is payable after sight, or any other case where presentment for acceptance is necessary to fix the maturity or due date of the instrument. Let's say the instrument says pay X 30 days after sight. When we say after sight, when the drawee first sees the instrument. And how will he see it? Of course, you have to present the instrument to him. He will see it, and that is when you start counting the 30 days. Okay? It is in order to fix the maturity or due date of the instrument. Okay? Second case, when presentment for acceptance is necessary. Of course, if the bill of exchange expressly stipulates that it must be presented for acceptance. And finally, in case the bill is drawn payable elsewhere than at the place of residence or business of the drawee, then it must be presented for acceptance. Please take note, in the previous video, I already mentioned that the drawee is not yet liable on the instrument until and unless he accepts it, in which case he will become the acceptor. So how will he accept it? Of course, it has to be presented for acceptance. So that's the purpose of this stage, okay? So in all the cases I mentioned earlier, when presentment for acceptance is necessary, the holder must either present the bill of exchange for acceptance or he must negotiate it to someone else within a reasonable time. And under the law, you determine what is a reasonable time by resort to the nature of the instrument, to the usage of trade, if any, or to the facts of the particular case. Okay? Because if it's not presented for acceptance or negotiated within a reasonable time, then the party secondarily liable, namely the drawer or the endorsers, will now be discharged and will no longer be liable on the instrument. Why? The reason is because these parties who are secondarily liable have the right to have the bill accepted immediately for the following purposes. Now, first, of course, to shorten the time of payment. Second, to put a limit, a limit to the period of their liability. And finally, to protect themselves by other means before it is too late in case the bill is not accepted and paid within the time originally contemplated. Okay? Now, presentment for acceptance, may be excused, it may be dispensed with. But if presentment for acceptance is not necessary, the effect is that the bill may now be treated as dishonored by non-acceptance. Okay? So, what cases will presentment for acceptance be excused? First, where the drawee is dead, or has absconded, or is a fictitious person, or a person not having capacity to contract by bill. Okay? Second case, where after the exercise of reasonable diligence, after a search or proper inquiry, presentment for acceptance cannot be made. And finally, presentment for acceptance is excused where although presentment has been irregular, acceptance has been refused on some other ground. Okay? Some other ground other than the irregularity of the presentment. Okay? So now, if the bill of exchange is presented for acceptance and acceptance is refused, okay, he does not accept, the drawee does not accept or cannot be obtained. Okay, that's the first. Or if the bill of exchange sige, let's talk about that second one later. In case of refusal or the acceptance cannot be obtained of the drawee, then of course, the bill of exchange now is dishonored by non-acceptance. Since the drawee did not accept, the bill is now dishonored by non-acceptance. Okay? Now, there are two other cases when the bill may be considered as dishonored by non-acceptance. First, in cases I mentioned earlier where the presentment for acceptance is excused, because again, I said the effect earlier, if presentment for acceptance is excused, then the bill is treated as dishonored by non-acceptance. And the second case, when we can consider that the bill is dishonored by non-acceptance, is if the bill was presented for non-acceptance and the acceptance was not given within 24 hours from the time it was presented, this is required under 136, section 136. Then section 150 now says the person who presented the bill must now take note, mandatory, must now treat the bill as dishonored by non-acceptance. If he does not treat the bill as dishonored by non-acceptance, then he will lose the right to go after the party secondarily liable, meaning the drawer or the endorsers. Okay? Why? Because under section 151 naman, when the bill is dishonored by non-acceptance, the effect is an immediate right of recourse against the drawer and endorsers accrues to the holder, The holder gets an immediate right of recourse to go after the parties secondarily liable. And no presentment for payment is necessary. Okay? In other words, the holder may immediately hold the drawer and or the endorsers liable for the value of the bill. Okay? He does not even have to wait for the date of maturity because it has not been accepted by the drawee. And take note, presentment for payment is no longer necessary. Why? Because payment cannot be expected anymore. The drawee did not accept it. Okay? Since the drawee did not accept it, it is reasonable to conclude that he's not gonna pay it. Okay? So presentment for payment is no longer necessary. Okay? There is no point in waiting for the date of maturity as well to present the bill for payment. Okay? The holder can now demand enforcement of the bill of exchange from the party secondarily liable, provided he gives notice of dishonor. Unless, of course, the giving of the notice of dishonor is excused. The law gives us certain situations when the notice of dishonor may be excused or dispensed with, no? First, of course, when it is waived, according to Section 109. Second is when, after the exercise of reasonable diligence, notice of dishonor cannot be given or it does not reach the parties sought to be discharged. Okay? Under Section 114, the drawer notice of dishonor is not required to be given to the drawer under Section 114 in the following instances, where the drawer and the drawee are the same person. I discussed this in my previous video. Second, when the drawee is a fictitious person or a person who does not have capacity to contract. Okay? Next, when the drawer is a person to whom the instrument is presented for payment. And fourth, where the drawer has no right to expect or require that the drawee or acceptor will honor the instrument. Okay? Under Section 115, okay, notice of honor naman is not required to be given to an endorser. Earlier, it was drawer. This time, endorser. Okay? In the following instances. No? First, when the drawee is a fictitious person or has no capacity to contract and the endorser was aware, okay, of that fact at the time that he endorsed the instrument. Okay? So, we don't have to give notice of dishonor in that case. Second, if the endorser is the person to whom the instrument is presented for payment. Okay? And third, where the instrument was made or accepted for his accommodation. Okay, finally, please just take note that in case the holder of the instrument failed to give notice of dishonor, no, to the party secondarily liable, and then the instrument is subsequently negotiated to a holder in due course who does not have notice that notice of dishonor was not given, no? Then that holder in due course will not be prejudiced in his rights by the failure to give the notice of dishonor. Okay? So that's for presentment for acceptance and then notice of dishonor. Okay? Now, that was if the presentment for acceptance was denied, no, or refused, no? Here, let's go to a different scenario. What if instead the presentment for acceptance, the bill was accepted? Okay? So if the bill was accepted, now the bill must be presented for payment. Okay? Why? Because for in the first instance where it's to fix the date of maturity, like 30 days after sight, you can present it for payment and accept at the same time as presentment for acceptance. You will have to wait for the due date. Okay? When it's the due date now, you present it again for payment. Okay? Because you cannot ask the enforcement of an instrument that is not yet due. Okay? Now, well, subject of course to the exceptions, no, that I mentioned earlier. Now, if the bill of exchange is accepted, it will now be presented for payment, which is simply the presentation of the instrument to the person primarily liable for the purpose of demanding and receiving payment. In a word, no, it is simply demand. No, it's the demand for satisfaction of the instrument. Okay? It consists of a personal demand for payment at the proper place with the readiness to exhibit the instrument if required and to receive payment while surrendering the instrument in case of payment. Okay? Again, it has to be personal. Okay? Meaning that the holder must be able to at least show the instrument if required. So it cannot be over the phone or text. Okay? So that's what the requirement of personal means, no, and exhibition, no. So as a general rule, presentment for payment is not necessary to charge the parties primarily liable, such as the maker or the drawer. Maker in case of a promissory note, or drawer in the case of bill of exchange. Why? Because they are already absolutely liable no matter what happens, no? Subject of course to the due date, no? So they are presentment for payment is no longer necessary to be given to them. Okay? So, meaning that the holder can sue the maker or the drawee, no? Or the acceptor, rather, when he accepts, no? Even before the maturity date. Because in the case of the drawee, he has already accepted, no? So, the importance of presentment for payment, no? And its denial, if any, no? Is only for the purpose of charging the parties who are secondarily liable with liability. Okay, do you understand, no? In other words, you need to present the instrument for payment, no, to the person primarily liable so that he can say, no, I am not paying that, in order for you to be able to go to the party secondarily liable, who are the endorsers, or in the case of a bill of exchange, the drawer, because the drawer is secondarily liable. Okay? The parties who are secondarily liable, they only undertake to pay only if the instrument has been dishonored by the parties primarily liable. Okay? So, demand should first be made on the parties primarily liable. Please take note of that, no? Okay? And that is done through presentment for payment. Okay? Now, that's the general rule, no? However, no, presentment for payment will not be necessary to charge the party secondarily liable in the following cases, okay? First, presentment for payment is not necessary in the case of the drawer, okay? If he has no right to expect or require that the drawee or acceptor will pay the instrument, okay? He has no right to expect that the drawee will pay, no? Why? Okay, because maybe he has no funds at all with the drawee, or he has withdrawn all the funds from the drawee such that the drawee does not have anything with him anymore. Okay? Or if the drawer and the drawee are the same person, in those cases, the drawer has no right to expect that the drawee will pay. Okay? So, presentment for payment is no longer necessary to charge the drawer with liability. Okay, but all other parties, no, will now be discharged. Okay, second instance refers to an endorser for whom an accommodation was made. Okay, this is in section 80, and it refers to an endorser for whose accommodation an instrument was made or accepted. Okay, so presentment for payment is not necessary to charge that specific endorser. Okay, he has no reason to expect that the instrument will be paid if presented. Okay, but no, that only applies to the endorser for whose accommodation the instrument was made. Okay, in other words, presentment must still be made, no, in order to hold the ordinary endorsers liable, no, those that did not rely on an accommodation agreement. Okay, and if there is no presentment, then those ordinary endorsers are discharged. Okay, now presentment for payment may also be dispensed with or excused, no, and it happens in the following cases. First, no, where after the exercise of reasonable diligence, again active search or make inquiries, no, presentment cannot be made. Second, if the drawee is a fictitious person. Third, the waiver of presentment. And finally, where the bill has been dishonored already by non-acceptance. So in that case, since it's already been dishonored by non-acceptance, no more need, no, for presentment for payment. It already has not been accepted. Okay? Now, delay in making presentment for payment can also be excused, no? Delay, the delay. But upon the delay will only be excused if it is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. Okay? But once the cause of the default ceases, no, it ends, presentment must now be made with reasonable diligence. Okay? So now, presentment for payment tayo. This time, it goes again into two branches, no? If the payment is refused, no? If payment is refused after presentment for payment, or in case presentment was excused in the situations I gave earlier, and the instrument is overdue and unpaid, then the instrument is now dishonored by non-payment. Earlier, we were talking about dishonor. The bill was dishonored for non-acceptance. Now, the bill is dishonored for non-payment because payment has been refused, no? So the effect is that an immediate right of recourse against all parties who are secondarily liable will now accrue to the holder. Meaning the holder, after he gives notice of dishonor to those parties secondarily liable, like the drawer or the endorsers, no? The holder, after he gives notice of dishonor, can now hold them liable on the instrument. Okay? As long as, remember, he gives notice of dishonor, except, of course, in the situations where giving of notice of dishonor is excused. I discussed that earlier, no? Okay. So again, after giving notice of dishonor, the holder can now enforce the bill and he can now get paid, no? Just take note, no, the notice of dishonor has instances when it may be excused, no? I mentioned earlier, but there's an additional ground in case of dishonor by non-payment, no? In which case, it is when notice of dishonor by non-acceptance has already been given, okay? So, in case of foreign bills, there is an additional step. This is known as protest. We'll talk about that in a different video when we talk about foreign bills. Okay? So, after notice of dishonor or in case of foreign bills, we have protest. And the final stage, no? The final stage, if the presentment for payment of the bill has been accepted, no, instead of earlier na it was refused, no? If the presentment for payment was accepted and payment was approved and the payment was actually made already, then the instrument will now be discharged. Okay? The discharge is the last step or stage, no? And the law says that discharge is the release of all parties, whether primary or secondary, from the obligations arising from the instrument. Okay, the instrument is now rendered without force and effect and can no longer be negotiated. Okay, because there's nothing that arises out of this anymore. The law also gives us the instances when an instrument will be discharged. First, no, by payment in due course by or on behalf of the principal debtor. Second, by payment in due course by the party accommodated, where the instrument is made or accepted for his accommodation. Okay? Third, by the intentional cancellation of the instrument by the holder. Okay? He says, I'm the holder. I say, no, I don't want it na. Okay, so I cancel it. It has to be intentional. And then the instrument will now be discharged. Okay? Next, no? By any other act which will discharge a simple contract for the payment of money. No, yung extinguishment of obligations. Okay? And fifth, when the principal debtor becomes the holder of the instrument at or after maturity in his own right. No? This is confusion or merger. Okay? And finally, now we have renunciation in favor of the principal debtor at the time of or after maturity. Okay? The instrument and all parties will be discharged if the renunciation is unconditional and absolute. But please take note, the renunciation should be in favor of the principal debtor, because if the renunciation of rights is only for the secondary party, it only benefits that particular party, thus and those subsequent to him, no? But those that were not benefited, they will still remain to be liable and they will not be discharged. The instrument will continue to remain in force. Okay? Now, the law also gives us additional grounds where parties secondarily liable may be discharged, no? Okay, this only applies to the parties secondarily liable, meaning the drawer or the endorsers, no? First, by any act which discharges the instrument, those that I discussed earlier, no? Second, by the intentional cancellation of his signature, of the signature of the party secondarily liable by the holder. Okay, let's say I'm the holder, I cancel the signature of a specific endorser. Then that specific endorser is now discharged. Okay, third, by the discharge of a prior party. Okay? Let's say I derive my title through a prior party. If he is discharged, then I am discharged as well. I will not be liable anymore. Okay? Next, by a valid tender of payment made by a prior party. Okay? If the party prior to me makes a valid tender of payment, then I am already discharged. Okay? Fifth, no? By a release of the principal debtor, unless the holder's right of recourse against the party secondarily liable is expressly reserved. Take note, expressly reserved. Okay? And finally, by any agreement binding upon the holder to extend the time of payment or to postpone the holder's right to enforce the instrument unless it was made with the assent of the party secondary liable, meaning with his consent, or unless the right of recourse against such party is expressly reserved. Okay? So, if a secondary party, no, the endorser or a drawer, pays the instrument, okay, is the instrument discharged? No, it is not discharged. It only cancels the liability of that particular secondary party who pays, as well as the party subsequent to him or who derived title through him. Okay? So what can he do? He can strike out his name and the subsequent endorsements, except where it is payable to order of a third person and it has been paid by the drawer, and where it was made or accepted for accommodation and has been paid already by the party accommodated. Okay? So that's it for bill of exchange. For promissory note, it's substantially the same, no? There is only one thing missing, which is presentment for acceptance. So the incidents in the life of a promissory note would be preparation, meaning completion of all the requisites of Section 1 and the signing of the instrument. Second will be the issuance, no, when it is issued, okay? Now, when the promissory note is issued. Then we have negotiation, when it is passed from one person to another. Okay? If an order instrument, through endorsement. If bearer instrument, then by mere delivery. Okay? Then fourth, presentment for payment. Okay? No more presentment for acceptance, presentment for payment. Okay? Unless presentment for payment is excused, no? I mentioned this earlier, such as when presentment cannot be made despite the exercise of reasonable diligence, where there has by waiver of presentment, etc., etc. Okay, so just take note of that. And fifth stage, no, just in case that the promissory note is dishonored by non-payment, then there must be giving of notice of dishonor to secondary parties to hold them liable. Unless, of course, the giving of notice of dishonor is excused, as I discussed earlier. Okay? And the final stage, the same with bill of exchange, in case the promissory note was presented for payment and it was accepted, no? Meaning there is payment, then the instrument will now be discharged. Okay? So those are the stages or the incidents in the life of a negotiable instrument. Let's now go to the interpretation of a negotiable instrument. The general rule is, no, if the terms of a negotiable instrument, meaning the words here, no, or the terms in the instrument are clear, then there is no need to interpret, and the instrument must be enforced as it is read. Okay? So the rules of construction or interpretation will only apply if the language of the instrument is ambiguous or there are omissions, no, there are blanks in the negotiable instrument. But in the case of the courts, where the meaning is doubtful, the courts tend to resolve in favor of negotiability, meaning that the instrument is negotiable. Okay? First rule, no? In case of words and figures, the words will prevail over the figures. Okay, if there is a discrepancy between the sum expressed in words and the sum expressed in figures, the words will control. Let's say in words it is stated 100 pesos, but the figures have 1,000.00, so it looks like 1,000. Then the words will govern. Okay, because the words are clear. Now 100 pesos. Okay. So reference may be had, but if the words, no, if the words itself, the words themselves are ambiguous, then reference may be had to the numbers to fix the amount. And what is an example of that? Let's say what is written is 365, 365s. Okay, so when you read those words, you might think, does he mean 365 or 3 pairs of 65? So 65 times 3. Although it seems like an argument that philosopher might say, no? But there are issues like that. Okay, believe it or not, no? So in that case, the words are ambiguous. Now you can resort to the figures to determine the intent, no? And if you see peso sign 3, then 6, then 5 dot 00, then you know that 365 means 365. Okay? Now, if the date when stipulated interest is to run is not specified, no? Meaning, like let's say, I promise to pay X 1,000 pesos with interest at 12% per annum. The date is not stated when it will run, no? Then the rule is interest will run from the date of the instrument if it is dated, and if the instrument is not dated, then it will be considered dated as of the time of its issue. Okay? That's the third rule. If the instrument is without a date, then it will be considered dated at the time it was issued. Okay? Fourth rule, no? If there is a conflict between written, no, handwritten, or printed, computer printed or whatever, lithograph, no, printed words, no, if there is a conflict between written and printed words, the written provisions will prevail. Why? Because the written words are deemed to express the true intention of the maker or the drawer. Why? Because they were placed there by the maker or drawer himself. Okay, so let's say in the case of a check, it says pay to the order of blank, no, and then you fill that up. If the person who makes the check writes after the words pay to the order of, then he says X only, then it is now payment to a specified person. The words to order that are printed are deemed not written, no, and overrun by the pay to X only. And now the instrument is considered non-negotiable because it is payment to a specified person. Okay? Next rule, no? If a person places his signature on an instrument and you are uncertain in what capacity he placed his signature, then he is deemed to be an endorser. Okay? Subject to the rules I discussed in my previous video, no? And finally, when two or more persons sign, how do you know if they sign in what capacity, whether joint or solidary? If they say, we promise to pay, let's say X and Y, no? It's X and Y, and they say, we promise to pay. Their liability is joint. But if X and Y make a promissory note or a bill, no? And they say, I promise to pay, that means either one of them is liable for the full amount and their liability is solidary. Okay? So that's it for the overview on how negotiable instruments work as well as the interpretation. And I hope you may have picked up a thing or two. Okay? Please stay tuned for my next episode and I hope to see you soon. Bye!